this is me. You heard I sat on the federal bench for a while. I chair the Court Technology Committee of the ABA Judicial Division, which means that there are a lot of judges who get together talking about different technological issues, including artificial intelligence, unsurprisingly, and generative AI. Uh, if you're interested in reading any materials that really have to do with judicial roles and things, this third bullet point is to something I was the principal author for the Federal Judicial Center. That's the educational arm of the federal judiciary. You can get the booklet, which is what it is, from the FJC website. Hopefully, we're going to be starting a fourth edition of it soon. I work with an organization known as the Sedona Conference, and you'll see that there is a set of documents, third edition resources for the judiciary, and a supplement to it. What this is intended to be a guide or whatever you want to call it for state or federal judges dealing with electronic information. So this is something you may be wanting to share with your attorneys and breeze through it yourself, especially to look at discovery and production issues that you may be involved with. For anyone's interested, you see I also have things posted with the Massachusetts Attorney General's office on criminal proceedings and the like involving electronically stored information. Unsurprisingly, there's a lot on that. I have to give you a disclaimer. The information in this deck and the presentation isn't legal advice. Please don't consider it to be. I'm giving you my personal opinions, and this is for information and education. So here are the things we're going to be talking about today. The nature of generative artificial intelligence, focusing on that, how it's used in litigation and the like. Model rules of professional conduct and GAI. Model rules, I'm going to be looking at them rather than the Texas rules, as far as I know, and I'm admitted to the state bar in Texas and all the district courts there. There are no substantive differences between what I'm going to be talking about today under the rules of professional conduct and the Texas equivalent. Then we're going to be talking about the federal rules of civil procedure. Again, that's my background on the federal side. I'm familiar with the state rules in Texas. Nothing significant as far as what is going on or what I'm going to be talking about, no variations. And last, what might be happening as we're going forward. I have 50 minutes, I believe, with you, and I apologize for having started a few minutes late. Please feel free to ask any questions, pose any comments you might want. And there are going to be materials you're going to be getting when this is over that I've done and some other folks might have done. And if anyone has any questions about anything, please feel free to reach out. So let's start about the basics. We're talking about generative AI, but we're also talking about artificial intelligence. But generative AI is a subset, if you will, of AI. The first thing I think we need to consider when we're talking about artificial intelligence as the tent in which GAI is to come up with common definitions. I have been at a number of presentations and spoken to a number of people. When you talk about artificial intelligence, after their eyes glaze over, they'll normally say something, and I may not agree with what AI is that they're talking about. So simple thing here, a couple questions. What do we mean by AI or GAI when we're talking? If we're just matching patterns, is that artificial intelligence? It could be, depending on how searches are being done and the like. And then the next you'll see if algorithms are used that learn, refine as data volumes increase, is that AI? The answer is yes, any of this and all of this can be artificial intelligence. We need to get our definitions straight as we're talking about different technologies. And by the way, I expect we're going to be seeing a lot of variations in general artificial intelligence, but the platforms are, there's already a proliferation of them. Some of you may be aware of the executive order that just came out from the White House not that long ago, directing federal agencies to look at artificial intelligence. We're going to be seeing a lot of regulation in that area. And again, we need to think about what's being regulated and what that's going to mean for us, our firms, our corporations, or the like. What do we use AI for? Pretty simple. We use it for a lot these days. Identification, pretty simple and straightforward there. Security, law enforcement, retail and marketing. I happened to be in Europe last week. I flew back to Newark Airport, and getting to passport control, I put my face into a little screen. It read my biometric information. I have a smart passport, which everyone has, as far as I know, because they've been issued within the last 5 or 6 years, that has a chip in it that records biometric information, and that's how I wound up going through passport control. Cell phones, we use fingerprints. Fingerprints are biometric information and the like. Retina scans or patterns to get into devices, pretty simple and straightforward. And why is that artificial intelligence? Pretty simple. We're sifting through large volumes of information, and we're either just matching what we've got, or there may be changes in a program to find certain things. So that's all AI. Law enforcement uses artificial intelligence all the time. For example, there are different devices that pick up gunshots. That goes into a database, identifies what the weapon might be, identifies the sound, and then tells law enforcement where the shooting has been. Retail marketing, same thing. It's used everywhere, pretty simple and straightforward, and I'm sure all of you deal with it every day, just in the outside world as opposed to the world of litigation or records information management. GAI, this is just a diagram of what happens. You see there's a database that's put together, and we could spend an hour talking about the database. If you are using a database to create something, the question is going to be where the database comes from. If you're going to be contributing to the database, there has to be some serious thought as to exactly what data you are contributing. Because, for example, if you're a law firm, you may be contributing unintentionally confidential information of a client. If you are in a corporate or business or government entity, same thing. If you're contributing to that database, consciously or unconsciously, you may be turning over intellectual property. You may be giving access to personnel information and the like. So the first question is, where's the database coming from? OpenChat or OpenGPT, OpenAI as the organization has just said that they're using current data as opposed to historical data. Think about what you're putting into the database. And if you're creating your own, think about what you're putting into the database to make sure it's not something that you should not be opening, the possibility that others get information that should not be getting it. Then after the database, whatever it is, there's a prompt. That's called the science, or whatever you want to call it, or prompts is called prompt engineering. I'm going to be doing an organization for something this afternoon for a national paralegal organization. And part of the discussion is going to be the future of paralegals. And one of my suggestions is this is a great area for non-lawyer assistants of lawyers to get into, learn prompt engineering, learn how you can create questions or whatever you're sending into that database through the platform to respond, because there's something that you might be able to make yourself invaluable with. And then last, of course, after the database is looked at through the prompt, something is generated, and that often can cause problems too, because there may be stuff that's generated that could be intellectual property problems, infringements and the like. That means that, for example, I expect there are going to be regulatory actions at some point, if not already, and there may also be litigation involving that, whatever is generated, and that means that what's prompted, or the prompt, may be subject to discovery, just as the content of the database might be. So again, there's something for you to think about, whether or not there's something in there that you can wind up doing, assuming that you want to get another job or something else to do. There's a way to do that. So let me stop for a second and ask if there are any questions. Julie, anything?
Not in the chat, not yet.
Okay, please, if you have any questions, let me know, because I just don't want to keep regurgitating all this stuff and not hearing anything from anyone for the next 40 minutes or so, if we could. Now, what is GAI being used for, and why might you, in what you do, be using it? First, drafting documents. I'm sure a lot of you have heard of smart contracts. Basically, what this means is that there is a database. The database may have any one of a number of prior contracts, may have documents in it, and you might, depending on the prompt, ask a platform, give me a contract or give me documents that address X. And that the platform will go through the database on the basis of your prompt and send you a number of paragraphs or an entire contract, the model contract, if you like, that you can be used. The idea with that is you can go through an enormous amount of information, and rather you going through it, a generative AI will go through everything and give you what you're looking for. Then legal research, we've seen that now. I'm sure a number of you might have seen that GAI is being offered through legal research platforms. Find me case law on X, find me an argument based on Y, and that can cause problems. We'll talk about that in a few minutes. Contract review, same thing as looking at the documents I mentioned before. You look at a contract that comes in, or you're drafting something, give me a contract that addresses, oh, I don't know, length of a contract, or addressing certain types of areas to discuss in a contract. Predictive analytics, this is risk assessment. See the civil side, for example, whether you file a civil action, whether you settle a civil action, whether you go to defenses of a civil action. There's a large amount of information that may be out there. For example, you may say, tell me every action that's been filed on X and how those matters were resolved. Or I'm in litigation, the cause of action is this. What are the defenses that might be used, and how have those defenses prevailed? And criminal side, we've seen that already for years now. This is where we saw some of the first litigation involving artificial intelligence and the like. And that is using databases to make predictions as to whether an individual would be a risk of flight either before conviction or after conviction. Something else somewhat controversial, there are a number of platforms out there these days that are offering, if we don't call it legal advice, offering ways to file complaints, forms of complaints, really in areas where a lawyer may not be involved. For example, traffic tickets or the like. There's been at least one lawsuit that's been filed on these platforms arguing that what is being offered is the unauthorized practice of law. One was settled, I understand another one was just filed. We're going to be seeing that. And there may be an issue there about access to justice. One of the big arguments being made in favor of artificial intelligence and generative artificial intelligence assisting in drafting documents and the like is that will improve access to justice. I have some doubts about that for a couple reasons. Number one, if we're looking back at the history, if you will, from the pandemic, when there were remote proceedings and the like, there were individuals who were in rural areas or members of disadvantaged communities do not have reliable internet access. I'm afraid now that we may have the same issues popping up with regard to rural populations, disadvantaged communities who want to use these various chat boxes and the like. There may not be reliable access. You need to be able to do this on the internet. And the other problem I have with these chat boxes for legal advice is that at some point, there may be issues involving experts. And I don't know how that's going to fare when someone has to secure an expert to be able to challenge whether something is done in the first place or not. Now, starting to be some discussions about that yesterday. I've had that with the Bar Association. I am a member of the task forces for artificial intelligence put together by the New York and New Jersey Bar Associations, and that's something I hope we're going to be talking about. Brainstorming something else, just come up with various prompts involving cause of actions or arguments with regard to discovery or the like. And that's a way to brainstorm, if you will, some ideas, summaries of legal arguments. That may be something we're going to be talking about later when things are being done to write briefs or the like. We know that generative AI has assisted in writing some briefs at some point, but that's a summarization of legal narratives. And last, this idea of changing legalese into plain language. Again, that's a prompt that says, I have this language, what is out there in the database that might make it something simpler for people to read or more understandable. Here's an example. This is a prompt that was done by a friend of mine. Deposition questions for a plaintiff in a routine MV accident in Massachusetts, just because she's in Massachusetts. And you'll notice the questions that were popped. Pretty simple and straightforward. These are some. Here are some more. And this is done by Kat Casey. Some of you may know, by the way, she is in Austin. This is something that may be put together by generative AI. The lawyer looks at it, a paralegal assisting a lawyer looks at it. Is this anything you might ask at a deposition? Probably not. There may or may not be more. But this is at least a start as to how generative AI can go through a database, come up with questions that you might be able to use or your lawyer may be able to use for a deposition, or perhaps a contract of an affidavit and the like. Now, some lawsuits that we've seen already or we will see soon involving generative AI. First, breach of privacy. I mentioned to you before the database that a generative AI platform may use. There has to be thought about what's going into that database. There may be information protected by laws. For example, Texas has a biometric privacy law. There may be information protected by that law. There are 12 or 13 states across the United States that have data privacy laws. Some of you may work for organizations or law firms that are multi-state that may be subject to these laws. There may be personal information protected by statutes or the like. So there may be causes of action there. Discrimination. We are seeing concerns being voiced by for example, the United States Department of Justice and the Equal Employment Opportunity Commission, which enforce various employment discrimination laws at the federal level that are talking about bias problems. For example, if you've got a database, a large database, and you're searching the database of individuals to get a job, if the database consists of 80% males and you prompt information as to who might be the best category of people for a job, you may be going to discriminate against minority populations who are not white males. That may be violations of laws. We could spend an hour talking about that, but something to think about. Again, this may go to number one, the database that's being used in the platform, or number two, the prompt that you're putting together. Something to think about, which is another reason I think prompt engineering is going to become a great area that's going to develop. I know that there are some law firms I've seen that are already beginning to come up with people who might be the prompt specialist. So there's something for you to think about. Now, malicious uses, disinformation, automated hate speech, scamming, deepfakes. We're going to probably see that a lot when we talk about generative artificial intelligence that might create images that are not real, that may put out information that's not real, and the like. New York State, for example, has just adopted into law a deepfake law, where if certain requirements are met, putting out something based on a deepfake is a felony. And I'm sorry, not a felony, may be prosecuted as a misdemeanor. Unfortunately, one of the things we're seeing generative artificial intelligence now already is in the area of child pornography. That children's images are being put into other adult bodies or the like in the attempt to obviously pander to the desires of individuals. That is likely a violation of federal law and of state laws. And last, of course, there's data breach. If information is going into a database, that database is being used, other people can access the database and the like, there may be a breach of data. This goes back to the breach of privacy that you see as the first point here. So these are things to think about when your organization is thinking about using generative AI, either going out to OpenAI or some other platform who might have access to data that's there, and may someone be able to come in and look at data that you're sharing. Also, something to think about if your organization is coming up with its own platform. And I know that's being done, for example, by some large law firms. Think about the security of that information. We don't have time to talk about cybersecurity here. But of course, Julie, when you want to do that someday, easy to put something together on that. Some examples of litigation that's out there now. First one, copyright infringement action. Information is taken from a book and other things that are copied. The argumentation there, you've got copyright infringement because the book, the text, whatever, are subject to copyright. And then, of course, the next one is also out of the Northern District of California. This is the argument that defendants are scraping information from consumers to train GPT, and that's misappropriation of information. I haven't followed these to see what's going on with them. We have seen some motions to dismiss that have been filed in actions like these. We have seen case law coming out that for example, under California law, has thrown out certain causes of action, but allows others involving allegations like this. Stay tuned on this. We're just beginning to see litigation on this now. OpenAI only went out into the scene actually about a year ago now. And as I mentioned, there's been a proliferation of platforms, a lot of information out there, and we'll see what happens as time goes on with those. I mentioned this before. This is in the employment area. The United States Department of Justice enforces certain laws. The EEOC enforces certain laws. DOJ has said it's going to be looking at AI as it screens out individuals, for example, with disabilities, because the ADA, the Americans with Disabilities Act, is something that DOJ enforces. And then look at the tests that might be used to determine whether or not someone might be hired or not. And then there's also this concept of accommodation. Accommodation may be allowing someone to be tested or submit an application in a different way. And there's a guidance on this available at the link. Now, what's been going on in the world? And the world is the United States. I'm not talking about what's going on across the world, because there are a lot of things happening, for example, in the European community, and then China and the like, regarding artificial intelligence. Just some things to think about. Your organization may be subject to some of these laws. Illinois, this is the earliest one of these laws that are out there. Illinois passed this legislation that essentially says, if I'm looking for a job and I'm a resident of Illinois, and I am in the first round being interviewed by artificial intelligence. I'm sure some of you have been on conversations with chats, different utilities or whatever, and you're not talking to a human being, you're talking to a machine. This Illinois law requires notice that that's going to be happening and the like, and if you fail to do that, there may be litigation brought against you. Maryland, pretty simple and straightforward. You can see no use of services during a job interview unless there's consent. And notice and consent are big in both of these things. Interestingly, New York City has just adopted a local law, went into effect on July 1st. Among other things, if a prospective employer is using an AI hiring tool, again, notice and the like, there have to be bias audits done on a regular basis to test what's being done and the like. And I expect we're going to be seeing more things like this on the state level. The way Congress is these days, I doubt we're going to be seeing anything on the federal level, at least by way of legislation. So we will see where this goes, but look to see the states that your organizations are doing business in, to see whether or not the organization might be subject to one of these laws that's popping up or a regulation. Now, if you're involved in litigation, either in-house in a corporate entity or government entity, or you're at a firm, here are things that I think are going to be part of the future. First, the question is bias. You're representing someone who was denied a job, and you do some initial discovery. You find out that AI was used to make a selection. What might you need to show if you're a plaintiff's attorney to get discovery into prompts and the databases and the like? And if you're on the flip side, if you're a defense counsel, what do you want to try to insist that a plaintiff has to show to get that? It may be statistics. It may be the basis, or it may be the information that was fed into the database. I talked about that before. Next question, what can raise a question of bias? So beyond the definition of bias, what might you as a plaintiff need to show, or what might a defendant be deemed to counter to say whether or not there has been some basis for discovery into bias or a cause of action? Allegedly proprietary algorithms. Operative AI says everything's available now. There are platforms out there that are not. Just generally available without paying a fee, signing a contract and the like. There may be protection of algorithms. What about that? The answer to that is, generally speaking, if you're with a regulatory agency or a government agency or in a litigation, that's what protective orders are for. Generally speaking, you don't deny discovery because something's proprietary. The party who holds the algorithm or whatever's proprietary asks for and gets an order that limits distribution of the information, limits access to information to certain people. Be careful if you're negotiating one of these things on behalf of someone, or you are talking to an attorney about this. That only applies to discovery. There are different standards if you're at a motion stage in litigation, there's an argument about an algorithm, or you're at trial. There are different things that come into effect beyond just exchanging discovery under a rule. Black box algorithms, I touched on this before, and this is algorithms that modify themselves as data is fed in and the like. How are you going to get discovery into that if that's an issue, how the algorithm worked? This is one reason why I think the idea of artificial intelligence and generative artificial intelligence may not be consistent with access to justice, because this is something you're going to need experts to help you on. You're going to need to know what questions to ask and the like. You may be retaining counsel for yourselves. You may have to retain someone who's going to be testifying in court. Next, role of experts, that pops right into what I just said a minute ago. And then the last big question, and that's competence of lawyers. You work with lawyers. The lawyers have to be competent under Model Professional Conduct 1.1. I don't know how you're going to address that if there's ever a problem, but we'll leave that for you guys to deal with someday. This is the ABA put this together, you see, 4 years ago now, that courts and lawyers should think about issues involving artificial intelligence. We talked about bias already, explainability and transparency. That's something that you may have to deal with when you're working with a government agency that's identifying or looking into something, or you're in litigation. Ethical and beneficial usage of AI, that probably goes back to the causes of action I talked about before, and oversight and vendors. This is an area that you probably will not be dealing with that much, but lawyers will be dealing with, and you may be called on to help. By the way, if you haven't seen this, and you might not have, the ABA just issued an ethics opinion involving use of generative artificial intelligence. It's number 50613. And one of the themes of the ethics opinion is that lawyers have to be supervising, but there are roles for paralegals here, again, non-lawyer assistants. So take a look at that. That may be a role for you if you're going to be doing prompt engineering, you're going to be working with these different AI or GAA platforms. Now, we'll touch on this a little bit, just some things to think about. Do your competence, and again, remember, I'm looking at the model rules of professional conduct, not the Texas rules. Some specific questions you may have. What does it mean to work with GAI? What are you doing with generative artificial intelligence? What does the platform do and how? Confidentiality, some specific issues here. I already mentioned protection of client confidences if the data set is being composed of certain information. Next issue might be a possible waiver of attorney-client privilege or work product if certain information is being fed into a database, and that information might be subject to privilege. And it's being made available to others because others have access to the database, or something is being generated that incorporates information that might be privileged. And last, something I think you are all going to be dealing with the concept of the duty to supervise. You as non-lawyer assistants of law firms or legal departments are going to be helping lawyers. The lawyers have an obligation to supervise you. The question realistically is how that's going to be done. Give you an example. You may see this outside of litigation. I already mentioned the New York City law that requires bias audits. And that means there's going to be some supervision that's going to have to be going on there, something else that you may all focus on someday. By the way, none of you are in Florida, but your organizations may have lawyers who are barred in Florida or in litigation there. The Florida Bar Association has just issued a proposed or tentative advisory opinion on artificial intelligence. If you just Google it, you'll find it. It just came out within the last few weeks. It has not been finalized, but again, it's something that addresses a number of topics, including the duty to supervise. California, I just saw this morning, California Bar is proposing a guidance or whatever on artificial intelligence. Again, you can just Google it. And that also is talking about the importance of supervision. So you guys are going to be supervised if you're non-lawyers. And the question is, again, what might that supervision look like? And what should you be prepared to help putting together some type of policies and the like with regard to the use of artificial intelligence or generative artificial intelligence in your respective organizations? Something about the future, this you can see is from an attorney pretty recently. I don't know if it reduces the number of tries an attorney will need, but that's what a lot of generative AI platforms are billing themselves as being able to do. Will it help accuracy and efficiency? We will see. Will it replace lawyers? We will see. One of the big concerns I know in the paralegal community is that generative AI or AI may impact on what you are doing and your jobs. I think it's an opportunity for you to increase what you do and make yourselves more valuable. We will see what happens with that. Now, a couple of things to think of about the future and what judges are looking at these days. This is Rule 11B of the Federal Rules of Civil Procedure. Why it's important is that when a pleading, and that may be a complaint and answer of certain documents, is signed, the signature constitutes a certification. You'll see here that there's been a reasonable inquiry by the signer for all these different things that are said in here. So if you fail to comply with the effect of your signature, that may be a violation of Rule 11B. And hang on, we're going to look at that in a minute. This is another rule that addresses the effect of a signature. This has to do with discovery. And you'll notice, again, when an attorney signs something, it's a certification that the attorney has done a reasonable inquiry and all these different things have been satisfied. Texas has the equivalent of this. I haven't seen any case law out of Texas yet, but I'm sure it'll be there. And with that, this is the poster child of things can go wrong when you're using generative AI. This is a civil action based on an injury by an individual involving an airline. And what happens here is the plaintiff's attorney sends in a brief. The brief goes in, defense counsel goes to the judge and say, Judge, I can't find these opinions or they're not cited for the proposition the plaintiff's attorneys are relying on. Judge takes a look, reading the order to show cause that the judge issued. The judge isn't happy, and the judge wants to know why the plaintiff's attorney submitted this brief. And then to add icing to the cake, after the order to show cause comes out, the plaintiff's attorneys continue to stand on the opinions, even though there are questions about whether or not the case law is correct. And here's what the judge did. Judge decides that there was a Rule 11 violation. Remember the effect of the signature. The firm is responsible as well as the individual attorneys for what the attorneys did wrong. The judge is not going to impose sanctions under a separate federal statute because there really hasn't been an undue delay caused by what's gone on here. And if Rule 11 is not a basis for sanction, the judge said, you know what? I have inherent power to sanction attorneys for certain conduct, and I'm doing it here. And then you'll see the monetary penalty that the judge imposed. Then the judge said the attorneys have to tell their client and the judges what happened here, the judges who are alleged to have written other opinions, but the court's not going to require an apology because compelling one is not a true apology. This got everything started. Northern District of Texas, some of you may work for firms in the Northern District, corporations that are litigating in the Northern District. This is the first local order that came out. And here the judge said, as you can see, attorneys and pro se's, pay attention to that one too. You have to file a certification about whether or not GAI is being used and the like. This is something that people may not be familiar with. When you're litigating in a particular court, and we'll talk about a federal court here, you have to comply with the federal rules of civil procedure in a civil action. There are local rules that a district court may have, and that includes bankruptcy courts and the like. And there are 94 judicial districts in the United States. They all have their own local rules. Bankruptcy judges have their own local rules. That may put additional duties on a party and an attorney for a party. And in addition to that, if you, for example, go to the Northern District of Texas or Eastern District of website, if you pull up the name of a judge, judges often have chambers policies directing more things be done in matters before them, both district judges and magistrate judges. And here a district judge in the Northern District of Texas used his local page, if you will, to say, this is something I want all the time. This is from a judge in Pennsylvania. My question with this one, or my problem with this, again, you'll see this is a judge who disclosed AI has been used. I'm a little concerned with Judge Bailson saying artificial intelligence, because artificial intelligence, remember I mentioned before about artificial intelligence has to be defined. I don't know whether Judge Bailson intended to focus on generative AI or just AI use. In any event, if an attorney is using artificial intelligence, whatever that means, a certain thing has to be filed with the judge. Before we go any further, I'll give you an example of what's going on here at the local court level. The Eastern District of Texas has, just as of October 30th, revised its local rules to address artificial intelligence and generative artificial intelligence. Those of you who are interested in this, this is General Order Amending Local Rules 23-11. As I said, it was signed by the Chief Judge on October 30th. And let me just tell you some things in here that might be of interest. There's been an amendment to Local Rule CV11 about signature of pleadings. It added a new section, subsection G, talking about use of technology by pro se litigants. The litigants responsible for the accuracy and quality of what's been produced with the assistance of technology. And if a pro se litigant chooses to use technology, the litigant is bound by the requirements of Federal Rule 11, we mentioned about before, and has to review and verify computer-generated content. No certification requirement, though, just an obligation imposed on the party. And in addition to that, dealing with the attorneys, Section 3 of this local rule, and this is addressing local rule AT3. Again, talks about a lawyer's duties, imposes a new subsection. If the lawyer, in the exercise of his or her personal judgment, believes the client's best served by the use of technology, and there's references to generative artificial intelligence platforms, the attorney is reminded or cautioned that certain technologies may create inaccurate content and does not replace the lawyer's important asset, the exercise of professional and independent legal judgment. If the lawyer, use those different platforms or research, you're bound by Rule 11 of the federal rules and all other applicable standards of practice, and must review and verify any computer-generated content. So look for these. There are going to be more of these as we're going forward. I just cited to you a couple ones that stand out in my mind. There are a lot of these popping up by district judges. There's an Eastern District, a bankruptcy court, I don't recall which one it is, that has a set of standards that now are equivalent to what the Eastern District of Pennsylvania has just promulgated. So law firms, corporate departments, you have to look at the federal rules, look at the local rules in the court you're in, look at chambers practices of the magistrate judge, district judge, bankruptcy judge you may be assigned to. Now, a couple things to take a look at in resources. And again, I've got about 5 minutes left. I'm encouraging any of you who have questions, please send them in. I'll ask Julie for any of those or comments in a few minutes. This is from the EEOC. As I mentioned before, the EEOC enforces part of the Civil Rights Act. This is using artificial intelligence in employment selection. The Federal Trade Commission is very active in the area of artificial intelligence and the like. This is the latest statement that came from them with regard to biometric information, what it might be used for and the like, under the Federal Trade Commission Act. Some other things to take a look at. Paul Grimm, a good friend. He was a U.S. magistrate judge, he said, in District of Maryland. He was elevated, was a district judge. Now he's dean at Duke Law School. He and Maura Grossman is a professor up in Canada, has done a lot on artificial intelligence. Here are a couple things that they published on evidence rules in AI. And then something else they participated in, this third thing here, materials for judges on use of AI. If you're using AI in any litigation or it's being used against you in litigation and the like, these are things you may want to look at as far as resources. And some other things, and you should have these, I hope. B.B. Donald is Bernice B. Donald. She is a retired Sixth Circuit judge. She and some other people joined with me to do a webinar for PLI, Practicing Law Institute, on GAI in the courts. And we were asked to more or less turn the content of the article into something for the PLI Chronicle, which writes or publishes various articles. That's in your materials to take a look at. I sent you a case law summary and the like on artificial intelligence. The one referenced here is updated in June. I did another one dated September 7. I hope I sent that in to Julie, and if not, I can do that again. And then there's also something I published by LexisNexis that I wrote on judges and generative AI. And just a few more things. Tom O'Connor is a forensic consultant. See him in a lot of matters involving CLEs with AI. Here are two things that he's published on, one on the New Orleans Bar Association blog about AI. So there are a number of resources for you, some of which you can get online, some of which will be included in the materials that will be available to you when this is over. And with that, I have a couple minutes left. Any questions, any comments? I'd love to entertain them. in the time I have left. Julie, anything I can answer for anybody or talk to someone about?
Not yet.
The last chance, guys. Julie, anything you'd like to ask about or question about?
I'll just have to get with you on your calendar to schedule something else in the future.
I'd love to do it whenever you want to. Maybe one of these days it can be in person again.
That would be
And,
lovely.
And Kat Casey, I mentioned, she's based in Austin, and I'm sure she'd be happy to join me one of these days. She's the non-lawyer perspective. She is the practitioner perspective, if you will, on doing different searches and other things. Great person. And I hope we get to work with her someday.
Excellent. Thank you. Last call for questions. All right. Thank
Okay.
Thank you, Judge Hedges, for an interesting and informative presentation. We certainly appreciate your time and all your expertise. For the registrants, we'll be sending out the presentation, slides, the link to the recording, and a certificate of attendance. Give me a few days to get all that together. And thank you very much for attending. We certainly appreciate your time. And thank you, Judge.
Thank you for having me again. And again, I apologize for dialing in a little late. My fault.
Yep, we're all good. And we're ending on time. All right. Thank you all
All
very
right.
much. Bye.
Thank you all. And happy holidays to everyone. Okay, Julie, I'm dialing off. Thanks a lot.
Oh, thank you very much for your time. I certainly appreciate the all this information. Excellent.
There's a lot to take back to